opportunity to reform at part with others over whom the pall of caste does not hang. Then we have dealt with Article 23, and we have said that such provisions often lead to an unfair distribution of labor within the prison system, with persons from specific communities performing honorable tasks, while those from marginalized communities are forced into undesirable work. We put that in italics. The type of labor assignment based on their caste cannot be classified as voluntary. Forcing the members of oppressed castes to selectively perform menial jobs amounts to forced labor under Article 23. Dr. Ambedkar had articulated that the socio-economic situation of oppressed communities should not be used to exploit their labor. Article 23 strikes at this philosophy. The said article is not a caste-ignorant provision, but a caste-conscious provision. Then we've dealt with the Model Prison Manual 2016 of the Government of India, and we have said that the model suffers from several lacunae. The first issue to be noted with reference to the manual is its classification of habitual offenders. The manual defines habitual offender as a prisoner classified as such in accordance with the provisions of applicable law or rules. We have highlighted that the phrase habitual offender in several prison manuals refers to people from denotified or wandering tribes. Therefore, this definition cannot be left to be interpreted and applied in accordance with the provisions of applicable law or rules. Otherwise, what it will end up doing is to classify and separate people from denotified tribes in prison without any basis. Second, the manual does not explicitly prohibit physical caste-based segregation of prisoners, except in prisons for women. This is concerning, as the manual was prepared in 2016, when prison manuals in different states mandated caste-based division of prisoners. The manual of 2016, therefore, should have adopted a specific provision prohibiting the classification of prisoners on the basis of caste for all prisoners, as it does in the case of women prisoners. Third, the manual does not prohibit division of work on the basis of caste, except in cooking. As analyzed, various prison manuals in different states specify different work to people on the basis of caste. Fourth, the counsel for the petitioner have argued that the manual does not refer to the provisions of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013, which prohibits manual scavenging. We clarified that the Act has a binding effect even on prisons in relation to toilets, manual scavenging, or hazardous cleaning of a sewer or septic tank inside a prison shall not be permitted anymore. Fifth, it has also been argued that caste-based privileges provided to certain prisoners are not forbidden, except in para 17.22. We clarify that no special treatment shall be given to any group of persons or individuals on the basis of caste in any scenario. In the next segment, we have dealt with the Model Prisons and Correctional Services Act of 2023, and we have said that the Model Act does not contain a reference to the prohibition of caste-based discrimination. Then we have said that the definition of habitual offender under section 2(12) is also problematic. And then in the next segment, we have dealt with the continued targeting of denotified tribes and said that the habitual offender legislations were enacted to replace the Criminal Tribes Act. However, in states such as Rajasthan, they were used to refer to members belonging to criminal tribes and denotified tribes. Applying that logic, several prison manuals or rules have also referred to habitual offenders to mean members of denotified tribes or wandering tribes. This cannot be accepted. A whole community ought not to have either been declared a criminal tribe in the past or a habitual offender in the present. It would not be wrong to say that the classification of habitual offender has been used to target members of denotified tribes. Next, we have referred to substantive equality, and where we have said, what does the future hold for India? Dr. Ambedkar had expressed this concern in his last address to the Constituent Assembly. The concern holds true even today. More than 75 years since independence, we have not been able to eradicate the evils of caste discrimination. We need an institutional approach where people from marginalized communities could share their pain and anguish about their future effectively. We need to reflect and do away with institutional practices which discriminate against citizens from marginalized communities or treat them without empathy. We need to identify systemic discrimination in all spaces by observing patterns of exclusion. After all, the bounds of caste are made of steel, sometimes invisible, but almost always inexplicable, but not so strong that they cannot be broken with the power of the Constitution. This petition highlighted an instance of institutional systemic discrimination. We appreciate the assistance provided by the lawyers in dealing with the issue. In light of the discussion, we issue the following directions. 1. The impugned provisions are declared unconstitutional for being violative of Articles 14, 15, 17, 21, and 23 of the Constitution. All states and union territories are directed to revise their prison manuals and rules in accordance with this judgment within a period of 3 months. 2. The union government is directed to make necessary changes as highlighted in this judgment to address caste-based discrimination in the Model Prison Manual of 2016 and the Model Prisons and Correctional Services Act 2023 within a period of 3 months. 3. References to habitual offenders in the prison manuals or Model Prison Manual shall be in accordance with the definition provided in the habitual offender legislation enacted by the respective state legislatures, subject to any constitutional challenge against such legislation in the future. All of the references or definition of habitual offenders in the impugned prison manuals or rules are declared unconstitutional. In this case, there is no habitual offender legislation in the state, the union and the state governments are directed to make necessary changes in the manuals or rules in line with this judgment within a period of 3 months. 4. The caste column and any references to caste in under trial and or convict prisoners registers inside the prisons shall be deleted. 5. The police is directed to follow the guidelines issued in Arnesh Kumar and Amanutullah Khan to ensure that members of denotified tribes are not subjected to arbitrary arrest. 6. This court takes suo motu cognizance of the discrimination against inside prisons on any grounds such as caste, gender, disability, and shall list the case from now onwards as in-rate discrimination inside prisons in India. The registry is directed to list the case after a period of 3 months before an appropriate bench. 7. On the first date of hearing of the above suo motu petition, all states and the union government shall file a compliance report on this judgment. 8. The district legal services authorities and the Board of Visitors formed in the Model Prison Manual 2016 shall jointly conduct regular inspections to identify whether caste-based discrimination or similar discriminatory practices as highlighted in this judgment are still taking place inside prisons. The district legal services authorities and the Board of Visitors shall submit a joint report of their inspection to the state legal services authorities, which shall compile a common report and forward it to the National Legal Services Authority, which shall in turn file a joint status report before this court in the above mentioned suo motu writ petition. 9. The union government is directed to circulate a copy of this judgment to the chief secretaries of all states and union territories within a period of 3 weeks from the date of delivery of this judgment. The writ petition is accordingly disposed of in the above terms. Pending applications, if any, shall stand disposed of. Thank you very much for your assistance. And Ma'am Sukanya Shanta, thank you very much for writing that very well-researched piece which got this whole proceeding started. But for your piece, nothing would have changed on the ground. And hopefully with this judgment, things will change on the ground.
Much obliged, Your Lord.
This just highlights the power of the law. When citizens, in bona fide petitions come to court, they write articles, they research on the ground realities, and then bring matters to court so that we can resolve them. Thank you for your assistance. Thank you, Ms. Vadekar. Please thank Dr. Muralidhar also, and thank you to Ms. Aishwarya Bhati on the other side, who argued also very objectively.
Your Lordship's leave.
Yes,
Sir. Mentioned about an extremely urgent matter which ought to be taken up today. And I'll tell Lordship why. Lord, I represent Isha Foundation, which is run by a very respected person called Sadhguru. We see him on TV, we see his lectures. It is an institution in Coimbatore, which has 5,000 people living there. We have schools, we have everything inside. So originally there are 2 ladies who are there who have been living there 10 years. 15 years. First, the mother filed habeas corpus 10 years ago in the High Court that they have been taken away, etc. They appeared, they are 30 or 40 years of age. And they said, we are living there of our own accord, that habeas corpus is disposed of. After 8 years, the father filed another habeas corpus. The father files, my lord, another habeas corpus on the same ground for the same daughters. They, my lord, again appear before the court 2 days ago on the first date and said, we are living here, they are educated, they are engineers. They are monks now, they are living there. They say we have renounced the world and we are living there. They made a statement in the High Court records. But High Court says that the father says, Lord, habeas corpus.
When was the second statement? That was again 2 years back? Or?
No, 2 days back.
Okay, 2 days back. Yes.
Lord, I have filed it over here.
Okay.
2 days back. The women appear, they are now 39 and 35 years of age. They are engineers and something else. So they appear and they say habeas corpus is over. The father says, I suspect that in this huge complex, there may be other people, my lord, who are also kept like this. The court says this is a very serious statement and therefore I order a police investigation to go into your ashram. So 500 people of the police, my lord, in my ashram since yesterday, examining every room, examining every person, and the High Court says, now you give me a status report. Habeas corpus is over, my lord. These are matters of which are contours of religious freedoms. People want to be a monk. Somebody will live, somebody will not live. But it's not a case of habeas corpus, my lord. These are contours of, my lord, this is happening. And all over, I respectfully submit, it's a one-page order, my lord. Keep copies.
Lord,
Lord, it's...
the Union of India.
Such a paper book?
Yes.
I appear for the Union of India. But this needs your lordship.
Lord, just have a look at.
The High Court should have been very circumspect, my lord.
Mr. Shankar, if you can give us even your iPads.
Yes.
On a returnable basis.
No. Lord, it can be on one-way basis also.
No.
We have provided to all our juniors, not on one-way basis.
So if the juniors get it, the Supreme Court is provided to my colleagues also. This is the effort to make our whole system digitized. Give me a...
My lord may have this. Now just see this.
Let's see first the order of the High Court.
What page? Not page 1 at page 2.
30th September.
Page 1 and page 2 passed below 2 days ago.
Yes,
Page 1 at page 2 below.
4 paragraphs order?
Yes. Yeah, correct. First day order. And my lord, both the ladies appeared. Because the lawyer told us that a petition is coming, we asked them to appear. Their ages are 42 and 39. We have examined both the detainees, the petitioner. Petitioner is a retired professor. Petitioner is a scientist in so-so, his 2 daughters providing education up to engineering. Both of them joined an institution called Isha Foundation. Now the grievance of petitioner is foundation abusing certain persons, brainwashing, converting the monks, not even allowing the parents to meet them. The situation is also widely criticized. Petitioner in person will submit. Even recently a criminal case was registered against him. Allegations was a person he molested. Counsel would submit there are several other cases registered. All below general, nothing. In view of the seriousness of allegations raised and the way the matter have spoken to us, we could form opinion some more deliberations are required to understand the truth. Therefore, petitioner produce details. Petitioner will produce, that is the other side, all cases, etc. The prosecutor will collect details. Next, last page. In para 15, it is stated that on so-and-so in the evening, his elder daughter suddenly called the petitioner's mobile, said his daughter is fasting so-and-so. With reference to the allegation, will conduct an inquiry, file a status report. And this is the second order after 8 years, below. The first order, below, was also there. Page 20, below, is the second order.
tell us one thing?
Yes.
This did the two monks, as we call them?
Yes. Now they are monks.
Yeah. Did they appear in court or were they statements?
Yes, physically. They are available online even now. I've told them to be available.
Did they appear in the court?
Yes, my lord. And they appeared.
The division bench.
Yeah, that's the first line.
Now wait, yes.
First line, my lord. The court has interacted with the detainees.
They have examined both the detainees.
Yes. And my lord, the mother.
They said in the court, has that been documented on the record or anything like that?
That may not be appeared.
Yeah, no, what they said in the court, because the judges don't record what they said.
No, this is all there is to.
Okay.
The lordships can ask them. And the first order in the mother's petition 8 years ago, same thing happened, my lord, which is at page 21. So it's, my lord, there is somebody behind all this, that this is going on. We have a blemishless record, 5,000 people live in this ashram, page 21. Kindly turn to page 20.
He said one aspect which we must put to you, the court has recorded the petitioner in person would submit that even recently a criminal case on the POXO has been registered against a doctor who is working in the same institute.
My lord, he's a doctor, it has nothing to do with us. He's not on these premises. I mean, my lord, we have millions of people who come there. The lordships are aware, Auroville, there's so many people you visit on a daily basis. You have Osho, my lord, in Pune. You can go daily basis, you can live there. So, how can this? You have a 500 people, my lord, in our ashram.
What to do with your ashram?
Sorry, sir.
The allegation against the said person was that he molested 12 girls studying in the Adivasi government school. What has this Adivasi government school to do with the ashram?
No.
Nothing.
No.
This fact.
Because that man kept saying, the court kept recording. Your lordship find is all oral. There is not a vestige of documentation. Yes.
Purpose why we are asking.
Yeah, correct.
Petitioner in person would submit that even recently a criminal case under POXO has been registered against a doctor who is working in the very same institution. Correct?
No, my lord, it's not correct. Your lordship sees page I. The answer is in page I.
Our response.
The second sentence. Allegation against the said person was that he so-and-so in the Adivasi government school. So after this incident, he is working in your...
Lord, it has not occurred in our premises. We have said that at page I, ground S. Kindly see. It can't be, my lord, on oral assertions. The High Court starts an inquiry. You violate our, my lord, freedoms.
We take it that part in the last sentence of para 1, that whatever criminal case against a doctor is the allegations.
That's all right, my lord.
That
we are not appealing for the doctor.
Difficulty about, because that must go on.
Yes, of course, my lord. How can anybody say with a POSCO case, we should say stop it? How can I say that? But I am only concerned, my lord, habeas corpus was over when these women appeared at age 42 and 35.
Habeas means bring the body.
They are there.
They were there. They were all 35, 40
several
years.
other, where they say that the counsel for the petitioner submitted that there are several other criminal cases registered and allegations are pending.
There is nothing on record, my lord. I can't just answer like this on that day. I mean, if somebody has some registered somewhere out of 5,000, I can look at it. But we have a blemishless record, my lord. And
referred to in the last sentence of para 1. Is he working in your institution?
no, my lord, answer is at page I.
Para S.
Come back, my lord, to page I.
Page I.
Page I, ground S.
So you have taken instructions in this regard?
Lord, it is working with us.
This doctor is not serving in your...
It is recorded, my lord. Page S.
Page I.
S. Page I, ground S. With us, my lord, it never happened in our premises. And your lordship may make it clear that the POSCO case against the doctor will go on. We have nothing to do with it. We have produced these women. They appeared on day 1. My lord, it happened earlier. This is history repeating itself at page 21. This is the mother's petition. 6-page order. They appeared. Then he also appeared.
Now, are the Mr. Vadi, are the two Are the two women online right now?
Yeah, we asked them to remain online.
Are they presently online, Mr. Agarwal?
Yes. Can you call somebody, please? Tell them to.
You need to open it.
Okay, some.
499 people. This is somebody else here. No.
You're on your feet, so we thought there's Dr. Guptami, at least we'll have some assistance.
I'm always eager to speak in your court, my lords.
Mr. Gupta, are you appearing in this matter by any chance?
I am mentioning another urgent matter to be taken today. I'll do this.
Wait a minute.
It appears, Lord, it appears there are 500 people, Lord, on the video where the video is off. I don't know whether it's for this case.
There is a mentioning education matter. I presume that is not related to this, sir. You're mentioning some other matter?
Yeah, some other matters. I'm mentioning is an education matter for.
I'll come back to you in a moment. I just wanted to verify whether you are in this mentioning matter, which is being presently mentioned before us. We'll come back to you. Don't worry. Don't get active. We'll come back to you at a party in person.
Ma Pushpavani.
Can you speak to them on phone? Yeah. We can put on the phone, the speaker. See the earlier.
So the argument is that we have been.
Supposed to do is, obviously you can't let the police, you can't get in the army or the police into an establishment like this. We want to put to you something which we would like your response on. What if we ask the District Legal Service Authority to request the Secretary of the District Legal Service Authority, who is a judicial officer, to visit the premises, talk to these two inmates, and apart from this, if there's any other issue, to submit.
Muting.
Video.
Yes. Where are they? Yes, ma'am.
I'm here outside. At Isha Yoga Center. I was just eating something. I'm sorry for joining late. I didn't know about this. This is my Mayu.
Yes, ma'am. What do you have to say? You are aware of the fact that your father had filed a habeas corpus petition.
Yes, we appeared at High Court for the same, and we explained that we are here at Isha Yoga Center by our own will. And we also told the Honorable Judge of the High Court that this harassment from our father's side has been continuing for the past 8 years.
Ma'am, what are your educational qualifications?
I've studied.
What we'll do is this. We'll pass that order now. We are staying the direction of the High Court to the police, because if 500 police, as you say, have entered the ashram without any prima facie opinion. At the same time, what we will do is that we also exercise a sort of a parents' pet jurisdiction.
Certainly.
Right? So we'll ask the Secretary of the District Legal Services Authority to, it's a very different thing from, police, suddenly 500 police. It's an officer who is responsible to us, judicial officer who knows how to conduct these proceedings, trained in that. We'll ask the Secretary of the District Legal Service Authority to visit the ashram, talk to these two women, because talk to both of them, interact with the other women inmates of the ashram and submit a report to us. I think that will be, we'll have
That's in fact exactly what took place last time. Page 24 bottom. Chairman of the Legal Services Authority, who is the district judge.
They make a submission. No, we're not hesitant in somebody visiting, etc. It may set some bad portents. Somewhere something happens, the order of the court is cited, now said district judge, send this, send that. Creates a problem. My submission is this. The Lordship may stay the order. These ladies are here, she's here. Again, you can tell her also. She said that 8 years ago also. Lordship, she can come to court, she can come to Supreme Court. If Lordship desires, I can call her to court.
14th otherwise, 14th October.
Or
they're both there.
there is a second person.
She's next to I just saw her put her.
Mr. Rohati, since this is a habeas corpus petition, we'd like her to come on screen with us in chambers, because normally we would have heard her in chambers if it was in a physical mode. So we'll retire for 5 minutes to our chambers. We'd like to hear both the inmates,
both the women
in
on
our
screen.
chambers on screen.
Certainly.
We'll come back in 5 minutes and we'll now the only thing is Jaggi.
Thank you.
Manoj will just confirm that the sister is there.
Is your sister with you also at this point of time?
She's here. She'll be here in 5 minutes.
All right. So what we will do is we would like to interact with you in chambers, ma'am, since it's a habeas corpus petition. And
Yes.
Our Registrar Information Technology, Mr. Hargurvinder Singh Jaggi, will just take your link and provide, he'll ensure that we are on the same link in our chambers. So just come and speak to us in 5 minutes. If you were here physically, we would have asked you to come to the chamber physically. Since we are on a virtual platform, we'll just do that in 5 minutes and we'll come back.
Yes, sir. Thank you, sir. Yes, sure, sir. Thank you.
Please come back. You can always be here. Solicitor, we'd like to ask you.
Very good.
Your Lordship will continue mentioning after
conscience.
hearings.
We'll do the other mentioning, we'll just finish because they don't have to wait. Yes,
There's a
just one thing. Puneet?
Urgent mentioning, my lords, this concerns an order by the Police Commissioner of Delhi dated 30th September. So this order was passed where the Commissioner prohibits a gathering of 5 or more persons. Now this impacts the city right now because the Navratra season is on, Dashera is on, Ram Leela cannot take place, my lords, Durga Puja festivities cannot. My lords, the problem is, no, my lord, that matter is a separate matter. Here, devotees come from UP, they come from Haryana. My lords, this impacts multiple states. My lords.
Solicitor General says that the order by the Commissioner of Police has been withdrawn.
No, my lords, my instructions are, it's still in place, it operates till the 5th.
The police is the subject of the union.
Go on the record.
Today matters are listed before Delhi High Court.
Because
for the Honorable
if
Chief
he's
Justice.
saying that on the record, then because my instructions were, it continues to the 5th of
Because police is a central subject.
Of course, my lords, we are very aware of this.
May I mention a death sentence?
May I mention, my lords, subject, my lords.
Mr. Gupta, just 1 second. Just 1 second, Mr. Gupta.
There is an order of demolition of the control pump. On 27/9, we lost in the High Court on 23rd. Now they are going to demolish.
It was passed on the 23rd.
The demolition matters, my lords, have always accommodated. So if it can be taken up.
Yeah, list before a bench presided over by Honorable Mr. Justice Suryakant.
Lordships. I mentioned the arbitration matter section 50 appeal where liberty was granted us to file SLP. We filed the SLP, it may come on 14th October, minutes.
Okay. That other matter which has to be tagged with the arbitration matter which we have kept on the 14th. Please go.
Lordship.
The second equivalent order.
Lordship, I have mentioned emergency parole for a death sentence prisoner. Your Lordship, I already allowed listing for tomorrow. The issue is that the last rites as per Muslim rituals is on the 40th day, which comes during the holidays.
Yes, coming up tomorrow.
Lordship, the issue is that tomorrow would be the only opportunity for the court, and then after that it would become. I'm only seeking that the state of UP be given.
Serve the list before a bench decided over by Honorable Mr. Justice Sanjeev. Huh? It's already listed. It's already listed.
Lordship, the issue is Lordship, may I explain? The issue is that it would come up for the first time tomorrow, and that would be the last working day. The state of UP may not be able to verify that the relative is there.
The Registrar Judicial will just tell you before which bench I have assigned it for tomorrow. You can then mention before that bench that give me liberty, or you can serve.
Lordship, may just permit me to serve the state of UP and direct them to
serve it on Ms. Garima Prasad.
Obliged.
Lords, may I mention a matter for urgent listing for tomorrow, Milords? It essentially deals with the eviction and demolition of a hospital running in Agra, Milords. We've lost in the suit before the trial court.
When was the impugned order passed?
Milords, the impugned order was passed by the first appellate court, Milords, rejecting my additional evidence, and which was challenged before the High Court. That the High Court has also dismissed.
Milords, when was the impugned order passed?
Milords, it was passed on 7th of August. Milords, we filed the petition. It was, Milords, it was also...
Milords, permission to mention, Milord, that woman... Milords, may I say?
Yes, ma'am.
With Milord's permission, Milord,
Milords, may I mention, Milord, there is a shoot at...
He's entitled to protection under the MSMED Act.
When was the impugned order passed?
Only on October 1st, Milord. This is the earliest opportunity.
Alright, we'll come back, you mentioned. Yes.
Milord, that woman, Milord, short service commission officer, Lordship said issued contempt, Milord. It's been supposed to be listed about 4 months, Milord. Any date after the break, Milord.
No,
on 14th,
that
Milord.
can be done on the email.
On the 14th, no, Milord.
Minors are about to leave.
Milords, there's a shoot at site.
Contempt matter, it can certainly be.
Milord, we have made that request about 10 times, Milord, to the registry, Milord.
Then what do I do? We have 34 judges handling 65,000 cases.
I vote on
after notice.
Yes,
fresh cases we give priority.
14th if it's possible.
It depends what
14th, Milord.
Milord, there is a shoot at site order, Milord. Shoot at site order, I'm mentioning, Milords.
Mr. Rotri, we had an exchange and an interaction with the two monks who are sisters, and they have indicated two things to us, that they are staying there since they are now 27 and 24, right? No, they were 24 and 27 when they went in 2009 or so.
Correct.
And they are staying there voluntarily of their own accord, and they don't want to leave the ashram. There is no compulsion on them. That's one thing which they said. Second, they said that the police were there for 2 days, but they left last night. The entire the police team has left the ashram. There is no police right.
Some are still there, but I may be wrong. They may be right.
And
but your Lordship may be pleased to stay this order, Lord. This order creates
the petition, diary number 45881 of 2024, the specially petition under Article 136 of the Constitution arises from an order dated 30 September 2024, passed by a division bench of the High Court of Judicature at Madras. We have apparently, do you have any instruction? The police seem to have left the premises.
I just say this, what if matters to be mentioned, your Lordship is going to take it up, not based on their mentioning, at least the state should be informed. I've just got to know from the news, my ear was not...
No, our order is, our petition is against the High Court's order. The High Court, the state is acting as the High Court.
I'm not aware what they stated.
But do you have any instructions on what
I don't have the petition. If I have the petition, I'll be able.
All right, we'll list it on the reopening, because we have to pass some interim order right now.
I'll just see that. If there is nothing against the statement, then that's not the issue.
It is only directed against the High Court's order.
Just
we have nothing against the state.
Moment, bro.
Please.
Blood, because the way it has been reported, on which my colleagues came running, they've collared.
Mr. Luthra, just listen to the order.
Yes, of course, Lord. I'm sorry. I'm sorry to interrupt, Lord, but it's my duty to point out.
A habeas corpus petition was filed under Article 226 of the Constitution by the first respondent seeking the production of his daughters, Geeta Kamaraj, and Lata Kamaraj, who he alleged were who he alleged were held captive inside the premises of Isha Foundation at Coimbatore. The division bench, by its order dated 30 September 2024, noted that it had, into invert commas, examined both the detainees and the petitioner. The order of the High Court does not specifically refer to what transpired during the course of the interaction between the High Court, between the bench and the and Ms. Geeta Kamaraj and Ms. Lata Kamaraj, and the corpus. In order to obviate, the petition was mentioned for urgent orders. Before that, you say, the High Court, after noting the submissions of counsel for the petitioner, to the effect that there were several other persons who were staying at the ashram of Isha Yoga Foundation in of Isha Foundation in Coimbatore out of compulsion issued a general direction ordering that, into inverted commas, with reference to the said allegations, Coimbatore Rural Police, having jurisdiction, shall conduct an inquiry and file a status report before this court. Into inverted commas complete. Stop. The petition was mentioned for urgent listing by Mr. Mukul Rohatgi, Learned Senior Counsel, on the ground that, in pursuance of the order of the High Court, about 500 officers of the Coimbatore Rural Police entered the premises. It has been submitted that the interaction with the division bench of the High Court took place in the open court, in the course of which both the individuals concerned stated that they were staying at the ashram voluntarily and without any coercion. Next. During the course of the hearing, we were of the view that it would be appropriate for this court to interact with both the individuals concerned, which we have done at the chamber hearing online. Good stop. During the course of the hearing, during the course of the interaction, both the individuals stated that they joined the ashram at the age of 24 and 27 years respectively. Good stop. The text of the order of the High Court indicates that they are presently 42 and 39 years old. Good stop. We have had the benefit of interacting with both the individuals who have stated that they are residing at the ashram voluntarily and without any coercion. Good stop. Moreover, they stated that they are free to travel outside the ashram, which they have done from time to time. Good stop. Moreover, full stop. They have stated that their parents have also visited the ashram to meet them periodically. In fact, one of the two individuals stated that she has participated in a marathon of extending to about 10 kilometers in Hyderabad. Stop. As regards the presence of police, in pursuance of the order of the High Court, it has been stated by the two individuals that the police have left the premises after conducting, they have left the premises last night, though they were there for 2 days in pursuance of the order of the High Court. Full stop. The submission which has been urged on behalf of the petitioners essentially is that while entertaining that a similar petition was filed by the mother of the two individuals about 8 years ago.
In which the father also appeared.
The same statement as was made before the High Court on this occasion was made by the two individuals. Hence, it has been submitted that recourse to us. Hence, it has been submitted that the filing of a second habeas corpus petition ought not to have been entertained on these facts, particularly having regard to the age, maturity, and volition of the two individuals. Next. At this stage, we are of the view that the ends of justice would require the following order. Bracket 1. HCP number 2487 of 2024 shall stand transferred from the file of the High Court of Judicature at Madras to this court. We permit the first respondent, who is the original petitioner before the court, to appear appear on the virtual platform, to appear through the video conferencing platform if he wishes to interact with the court in person, or through counsel, either on the same platform or physically as he may desire. Semicolon. Bracket 2. The report, which was the status report, which was directed by the High Court to be filed by the police, shall be submitted before this court. Semicolon. Bracket 3. Further proceedings in person. Further, full stop. The police shall not take any further action in pursuance of the directions issued in paragraph 4 of the impugned order dated 30 September 2024, 7 except for the submission of the status report to this court.
Only one correction. I made a mistake. I said 500. The petition says only 150 police. Lordship may correct.
But there's one thing.
I was told orally 500, but the petition records 150 police officers.
But Mr. Rothki is right. But may I just add one more thing? Not just one thing I need to add.
Sure, we have, besides Mr. Full stop, Mr. Siddharth Lal, Senior Counsel, has appeared in these proceedings on behalf of the government of respondent.
But one statement I want to make, but just to clarify, but the petition at page R says 150 people, and what makes unfortunately a statement that police forced the persons to give handwritten letters as per the asking. What I want to point out factually was one, that the police was accompanied by the district child protection officer, the district child welfare committee, the district social welfare officer, 2 psychiatrists, and the JD health, and the drugs inspector. So, Lord, I'll give the list of all these officials. So they were all part of the team, Lord. It can't be, Lord, because they're trying to.
I'm saying nobody's gone.
No,
how can anybody go like this?
I'm sorry. I think Mr. Rothki is absolutely wrong.
Just say this. Mr. Siddharth Lal,
Notice the High Court gives an order. Do I not?
I'm not blaming you. I'm saying High Court should not have made an order.
States that the police team which conducted the inquiry in pursuance of the impugned order of the High Court was accompanied by bracket 1. Just put it.
I'll put it down in writing, Lord.
So we'll list this now on the reopening after the mini break.
That's right.
When would your Lordship?
That will be on the 14th. Of 14th.
Lord,
your Lordship
may request. The report will be directed to be the status report may now be submitted by the Standing Council for the State of Tamil Nadu to this court.
Yes, may I suggest your Lordship may call it on 18th, Lord. The 14th will be the reopening days and filings, etc.
18th
maybe
18th is fine.
Only one request, my Lord. Lord, only one request. I am for Union of India. Lord, this observations orally were made by the bench, which, my Lord, could have been avoided if your Lordships can consider stay of further proceedings before the High Court. My Lord has seized off the matter.
We have transferred the proceedings to our court.
Then there is no reason.
That's fine.
But the union is a party here.
No, I'm going to add the union because
yes, sir, we are concerned.
Mehta is always welcome. Mr. Mehta is always welcome, Lord. I just have one thing to say, Lord, and it's always a privilege to have him around. Now, Lord, just one thing I must point out, Lord, your Lordship is doing it for the 18th?
18th.
My Lord, I have filed an impeachment for the union. Your Lordship may add them, my Lord, because this has
fair enough. I didn't have this.
Far-reaching effect, my Lord.
My learned friend, I was aware, I was made aware. Now, Lord, I have just one thing to say, Lord. We would not have troubled your Lordship and come running, except that it seems there were some statements made by your Lordship which would seem to have been misquoted by the press, as if there was something came, as if your Lordship had observed in the police. So therefore, Lord, we came running. Otherwise, we would not have.
We were listening to what Mr. Rothki was arguing.
No, this is the problem of the media. The court did not say a word. I did not say a word about the police.
We were just executing
the High Court.
Grateful. I didn't realize.
Very good.
Thank you. We got the copy of the application. Grateful.
And the only thing which we indicated was we'd like to hear them in the privacy of the chamber because the habeas corpus petition.
But that's appropriate. But it's always better. There are some things better done in chambers than in court.
Grateful.
Much good. Most grateful.
Okay.
Jet Airways, we will have to keep it on the reopening book. I have to.
Give your parents.
I can't finish it now.
So, Rothki, you have never said that. You always take less time than what you tell us. we'll keep it on the reopening, right? And the same board, since we are now rising, my learned brothers have a separate board which will be taken up. This board will be repeated on the 15th.
So not everybody knew after that the note came, not everybody could understand what it is. So there was a separate note, this will happen, so we were all aware of it.
Okay. So my learned brothers will continue with the board.
So very good.
May I mention, Milos, I'm
site order issue.
Happy Dussehra, so that we will not come after this.
All members of the bar are very happy Dussehra.
All of
there is a shoot at site order, my lordship.
If everybody is going to scream at the same time, we'll just rise. If there's going to be some order, Mr. Gupta has been waiting for a while.
Yes, there is a shoot at site order of leopards in Rajasthan, Udaipur, my lords. And my lords, there are forest guards, there are shooters called from Hyderabad, my lords. They are on the field. I am requesting for today. It is against the guidelines of the National Tiger Conservation Authority, my lords. And we got the order yesterday at 10 o'clock through social media. There are copies, my lords, I'll pass on.
Before the bench presided over by Justice Gavai.
Today, my lords. Today, my lords.
All right. Then education matter, sir.
Yes, my lord, it's education matter. It's admission matter in MBBS Chandigarh College, which is pending since 2019. And
that will come up on the reopening. Yes.
I'm mentioning.
Mr. Solicitor, you want to mention something? Mr. Solicitor, you are.
Yes, my lord. I wanted to wish happy Dussehra to all three of your lordships, but with a request to enjoy the Dussehra vacation, my lord, and not to work.
That's never a reality. It's all of us are going to be preparing judgments which are pending.
I know, my lord. I know. That's
with my last permission, I'm mentioning a fresh matter. My lord,
Just cool your heels a little bit. Just because you are give you an authority to raise your voice, right?
Because I joined the learned Solicitor General, wishing happy Dussehra.
Anybody here who wants to mention anything?
I'm only asking, today's board is on the 15th now.
Yes.
That's great.
Mention item 7, which is the eligible matter of a disabled candidate. The counselling is going on. So if your lordship is kind enough to list it at 2 p.m. at any other...
It will be listed in the combination before Justice Pardiwala and Justice Manoj Mishra right away. No difficulty.
Don't break the line. Don't break the line. Now continue first.
Scheduled to be, it's for today, my lord.
Sorry?
The petitioner sought to be dispossessed today, my lord. He is an MSME entrepreneur.
When was the impugned order passed?
October 1st. My lordship will kindly take it on board today.
Who's dispossessing you?
My lord, these are surfacey proceedings. This is a MSME petitioner. He's entitled to protection under the MSMED Act, my lord.
This impugned order was passed by whom?
The High Court of Bombay, my lord. On October 1st.
He'll come up before the regular.
My lord, this is a 74-year-old person, my lord.
We'll reinstate you. And why do you go to the High Court of Bombay? You should have gone to the DRAT. So
my lord, he's entitled to protection under the MSMED Act, my lord. The DRT does not have jurisdiction to...
But we'll not pass any order without your circulating. You could have circulated the matter even yesterday. Yes.
Yes, my lords. Apologies for the...
yes, come on.
Previously, my lords, I'm running my querying operations and managing operations 2015. Now, suddenly, a month back, it has been suspended without any...
the same matter which was mentioned yesterday?
No, my lords. We are mentioning for the first time. 2015, I'm running without any difficulty, no issues. In fact, there are two...
So, for 1 month, you are not
running. My lords, and the impugned order by the High Court, simplicity issues notice. I press for a stay.
On the reopening, yes.
My lord, as advised by your lordship, I have deleted the name and I request you to list my matter tomorrow, sir.
Now it will come up. Not tomorrow, it will come up on the reopening. Yes?
I was mentioning that additional evidence matter, my lords, before your lordship rose up, my lord. Because my difficulty is that, my lords, the day after tomorrow, the first appellate court is concluding the matter, my lords. So I am requesting my lordship to have it tomorrow, my lord.
It's a ground which you can take up while challenging the order. Yes.
You
made it clear. Yes.
That item 8 is that regular bail where I'm in custody for 14 months. My lord, I had it after 2 days. 2 days back, my lord, it listed today. Is that ED matter, my lord? In case your lordship may have it today.
It will come up immediately at the bottom of the board of Justice Pardiwala and Justice Mishra.
I'm so good.
My lords have said that it will be Jet Airways, Godavarman and then marital rape, my lords. But my lords, for about a long time, we keep getting displaced, my lords. So we'd be extremely grateful if on reopening...
Same order will be maintained. Jet Airways is parter, then comes the Delhi Ridge matter and then this matter.
But if we could really be heard on that date, we'd be extremely grateful.
That I'm not sure because it depends on all of you. We are here to hear every matter. But sometimes getting lawyers to argue is more difficult than deciding a case.
We've been there on every occasion. Happy holidays, man.
Judge's pension matter.
Yes, Nima.
That judge's pension matter, my Lord, Lordship said take it today. First matter, Lordship said.
On the reopening. No, that will come up on the reopening. Because that requires a 3-judge bench.
Could I mention item number 13, my lord? 30, which is listed before your lordships today. It is that matter in regards to security and 1700 crores award in favor of the NHAI, my lord.
That will come up on the reopening. Right? 15th. Yes, 15th, the board will come up.
Lords, may I at least request for reopening Lords 14 if possible?
Yeah, that does.
Lords, may I mention a matter that was listed on Monday, 30th of September. Lords made certain observations which were dictated. Lords, these were eventually got missed out from the final order. So, Lords,
final order is the final order.
Lords,
observations in court during the course of the hearing are matters which we will decide.
Those observations are still in the Mr. Courtmaster's book. So,
how do you have access to the Courtmaster's book, I say?
Lords, we cross-checked. Before mentioning Lords, we cross-checked.
With which Courtmaster?
Lords.
Did you tell him what was dictated in the court? Did you have this conversation with him? He says something to the contrary. How dare you ask the Courtmaster what was dictated in the court?
I'm sorry.
Tomorrow you will come and sit in my house and ask my secretary what I am dictating in the chamber. The order which is there is the last order. Show me what was dictated. What is it that you want? Lawyers have lost all sense of decency or what? The final order is what is dictated in the court. What is signed by us. So what was there? What do you want? We have appointed an arbitrator.
Milords left the contention open for the existence of the arbitrator, the agreement and the limitation question for the arbitrator to decide.
But that is always so. That is always so. All contentions are open. In a section 11 matter, you only say that you are appointing an arbitrator. Yeah, we have only appointed an arbitrator. You can always move an application under section 16. And don't try this kind of funny tricks with me again. Huh? I don't have a very long time around on the bench. But until the last day I am in charge. Don't try this. Going to my secretary, going to the steno. Aapne usse bataya kya? And then you tell, because why would he tell me? Unless you know shorthand. Up and down.